For this last section, we'll look at those risks, those common risks to international business transactions. These are the type of risks that arise over and over again. And the first is something that we've alluded to before, and that's the risks associated with great distance, the distance risks. We have, and there are subcategories of risk in there. First of all is payment risk. You are a seller of goods. You put the goods onto a container ship. You ship the goods halfway around the world. 4 months later, they are delivered in a port in a continent far away. You as a seller want to be sure that you are going to collect on the sale of those goods. So there is a payment risk always associated with the sale of goods. And along with payment risk, of course, is credit risk, meaning you've extended credit to this person. What sort of guarantees do you as a seller have that that person will repay the credit? Another type of risk would be supplier risks. Questions of whether, if you are a company that manufactures bicycles, for instance, and you require a certain type of frame that is made in China, you as a buyer of goods are essentially putting your entire business into the possibility of these frames not being delivered, not being supplied per the agreement. Not only not being delivered, but also the question of, are they of the same quality that you as a buyer were expecting? So there's a supplier risk. And again, caused just by long distance. Finally, there is a marine risk. Most goods sold internationally travel on a ship. They travel on a ship, and ships remain subject to all sorts of risks just because they're ships. Whether that is weather, probably the largest single risk, whether it's something like piracy, which certainly we know occurs today, whether it is mechanical failure, or a ship becomes stranded, a ship becomes lost. All of those special forms of problem, risk associated with shipping goods on ships. There was one specialized case that we saw in your book. There's a case called Transatlantic Financing Corp versus the United States. And in this case, there was a sale of goods, and the goods were to be transported from the place of sale to the place of purchase, and they were going to go through the Suez Canal. Now, the Suez Canal is a major shortcut for goods that are coming from Asia to the West. It connects the Mediterranean Sea with the Indian Ocean, and therefore is a major shortcut. In the case of Transatlantic Financing Corp, both parties assumed that the goods would be transported through the Suez Canal. Nevertheless, neither party put any provision of that sort in the contract between the two. Well, what happened in 1956 was a temporary closing of the Suez Canal by Egypt. Egypt refused to allow ships to go through the Suez Canal, which required the goods in our particular case to be transported all the way down Africa, all the way down the African coast, across the Cape of Good Hope, and back up across the Atlantic Ocean. This entire extra part of the voyage added 3 or 4 weeks to the voyage, as well as cost thousands of dollars extra. Now, the company that had to pay objected to this payment, saying, we should not have to pay this extra amount. This was something beyond our control, the closure of the Suez Canal. Well, the court disagreed. This case goes all the way to the U.S. Supreme Court, and the court disagrees and says no, that in fact, although the parties both assumed the goods would be transported through the Suez Canal, there was nothing in the contract to that effect. Therefore, there was nothing to excuse one party or the other for what occurred when the Suez Canal was closed. Therefore, the fact is that there was no relief, even though there was additional costs and late penalties associated with the delivery of these goods. The court said that if this provision, if this idea of transporting through the Suez Canal was part of a bargain for agreement, then it should have been included in the agreement. And one could easily have included a provision that if transportation is not available through the canal, then there will be an extra charge incurred. There are also language risks involved in an international business transaction. Contract formation, where parties speak different languages, can be a large issue. Contract formation may require the use of native speakers, as to minimize the possibility of ambiguities. In the relevant case on this is the Gaskin versus Strumhandel, which involved an employment agreement between a United States citizen and a German employer. The United States citizen could not read German. The contract, the employment agreement between the citizen and the employer, was written in German, completely in German. Nevertheless, Mr. Gaskin signed the contract anyway. Even though he could not understand the words. Well, subsequent to that, when there arose a dispute between the two parties and Mr. Gaskin tried to avoid his responsibilities under the contract on the basis that he was unaware of what the contract said. The court disagreed, however. The court said if you don't want to be bound by the terms of an agreement that you could not read, then it is incumbent upon you to find someone to translate those words for you before you sign the contract. So, in essence, the lesson that we get is that if you sign a contract, even if it's not in a language you understand, you're going to be bound to the terms of that contract. Now, there are other types of risks. There are trade controls risks. We've seen a lot of this recently, in which the United Nations or various groups of countries have imposed sanctions on other countries. And as a result, this has caused inhibition of trade in both directions. There are things that a U.S. party cannot export to Russia at the moment, nor are there things that Russian company could export to a buyer in the United States. So obviously this is going to produce particular issues: export controls in both directions, sanctions, high tariffs, which is a customs duty. It's a charge placed on a good simply because it crossed a border. Certainly those tariffs can go up, they can be increased, which could cause severe unexpected problems for a party who's priced it on the basis of one amount. Currency risks. Obviously, monies have been free floating for some time, and what that means is that the US dollar, for instance, is going to be a certain amount, will buy a certain amount of euros. That amount can increase, or that amount could decrease. And if you have a contract that is denominated in euros, for instance, then if the value of the euro goes up, then that contract becomes much more expensive for one party than the other, or vice versa. So there are exchange rate risks. The case on that is Bernina Distributors versus Bernina Sewing Machine Company. And what occurred there was a change in the exchange rate, and the Swiss franc rose dramatically against the dollar. Now, the contract was between a Swiss company and a United States company, priced in Swiss francs, but the problem was, as the Swiss franc grew up in value, that price far exceeded what the U.S. Company was willing to pay or able to pay. The importer tried to protect itself, but again was bound by the terms of the agreement. The final risk we're going to discuss is political risk, legal risks. Political risk can arise because of a change of government, because of a change of type of government, but from mere political change, war, terrorism. There are any number of reasons that risk could be imposed to a contract by politics, even though the contract itself has nothing to do with politics. There's also the problem, a potential problem, and we've seen this happen a lot during the post-World War II era, of nationalization. Many companies were nationalized by the government. Nationalization is the transfer of a private sector firm to a government ownership. And what could occur is a company has invested in a foreign company, and then the foreign company is nationalized. It's taken over by the government, and there may or may not be sufficient monies to pay for the nationalized property. We also call that expropriation. Expropriation occurs when the government takes privately owned assets without adequate compensation for them. Confiscation is expropriation without any sort of payment or compensation. All of those are part of political risks that occur, essentially meaning a loss of the investor's property. And finally, exposure to foreign laws and foreign courts. Legal risks can arise in the course of an international business transaction.